Constitutional Court has ruled that a section of the Drug Trafficking Act is inconsistent with the Constitution because it criminalises the use and/or possession of cannabis by children. The court has suspended the order for 24 months to give Parliament time to finalise a legislative reform process. The application was launched by the Centre for Child Law, and we are now joined by University of Pretoria Centre for Child Law attorney Stanley Malematja. Very good morning to you. Thank you so much for your time. Talk to us about some of the concerns that have come out of this.
Good morning, and good morning to your viewers. So essentially what the Constitutional Court has done in this case is that it has confirmed that the criminal justice system is not the appropriate forum to deal with children who are found in possession and or those who use cannabis. So the Constitutional Court essentially found Section 4, subsection 1, paragraph B of the Drugs Act to be inconsistent with the best interest of the child, the right to human dignity of the child, and the right to equality. But what we need to clarify, especially for the benefit of the viewers, is that this case was not about legalization. It was rather about decriminalization. Now, the difference there is that with decriminalization, children are still not permitted to possess or use cannabis. However, should they be found in possession or using cannabis, the consequences that are going to follow that act are not going to be those of a criminal nature. So there will not be a criminal sanction. But to make it clear, what we are saying as the Center for Child Law and what the court has found, we are not saying that children should be permitted to use cannabis, but what we are saying is that the criminal justice system is not the appropriate system to deal with children who are found in possession or those who use cannabis.
What does the ruling clarify when it comes to drug use by children?
So what it clarifies is that the court entered into a balancing of rights in terms of Section 36 of the Constitution. And the court agreed with the Center for Child Law that there are less restrictive means to deal with children who use cannabis or who are found in possession of cannabis. And even the minister in the case actually considered that incarceration and criminalization is not effective. It does not bring about any benefits to a child who is found in this situation. So the court went on to find that there are provisions in the Children's Act that are rather more suitable to deal with children who are found in possession or children who are using drugs. Because the issue of children using cannabis is not a criminal issue. It is a social issue that can be fixed through engagement and through the engagement of appropriate social services. For example, we have the Children's Act. The provisions of Section 150 allows us that if a child is found to be addicted to a particular substance, for example, dagga, that child can be declared to be in need of care and protection, and they can be provided with the adequate services that target the core root of the issue, being the drug abuse.
I suppose this shows efforts to use a more child-centered approach in keeping children out of the criminal justice system.
Indeed, Mpo, because we need to remember that, our Constitution has long found that when we have laws that are geared up to protect children, immediately when those laws are the same laws that end up infringing on the rights of the children, then it means that there's a problem with the law. So due to children's vulnerability, they need the utmost protection, and incarcerating them is not in their best interest, because we need to remember here that when a child is incarcerated, or any person for that matter, when they're incarcerated, but particularly children, you are taking away that child from family care, you are removing that child away from society, and that is not helping the child, because in incarceration, the possibility of that child being exposed to more dangerous and illicit substances is rather high. So the incarceration really does not bring about the right answers, and it is not in line with Section 28, subsection 2 of the Constitution.
So does this now apply to other illegal substances, or is it just cannabis specific?
Yeah, that is a very great question. So this judgment is cannabis specific. It does not apply to any other illicit substances. So if a child, for example, is found in possession of maybe mandrax or cocaine, that child can still be arrested. This order is specifically on the possession or use of cannabis and not to any other substances.
Is this perhaps a directive to open up the bigger conversation to other substances, or were there specific reasons why it was only cannabis focused?
There were specific reasons why it is only cannabis, focused, because this case on its own, I'm not sure if you are aware of the Prince case where the Constitutional Court found that adults may cultivate and use cannabis in their private spaces.
Yes.
So then it is that case that actually opened up this to say that it cannot be that in a democratic country, a child can be criminally punished for something that an adult is allowed to do. Then what we said is that, okay, we do understand that the Drugs Act is there, or rather the intention is there to protect children against the use of drugs. But then if that protection then ends up leading to incarceration, then that is not the protection that is in the best interest of the child. Mm-hmm. So what we argue is that given that adults can use in their personal spaces, what we are saying is that incarcerating a child and that child and leading up to a conviction and a criminal record, it is not in the best interest of the child, because it leads to a lot of things. It leads to stigmatization. It prohibits the child from participating in their adult ages. It will prohibit that child from participating in the employment world because of the criminal record. Then we rather said, look, what needs to happen is that the issue of drugs, it is a social issue. And we know that we do have social facilities such as the Department of Social Development. Then it should be those particular departments that deal with this, since it is a social issue and not a criminal issue. That's why we have the Children's Act that is already providing guidance. Then we also have the Act on the prevention of the use of substances. So that is our line of argument, and the Constitutional Court found in our favor in that light.
Very well. Thank you so much for that clarity. University of Pretoria Centre for Child Law Attorney Stanley Malematja.